Hi, everyone. It is about 12:05. I'm going to go ahead and get started. Thank you so much for joining today. This is the second webinar I've done. The first was basics of business, and we focused on formations, contracts, and hit trademarks just a little bit. But from feedback I got from you, people really want some more information about the trademark process, and that is one of my favorite topics. So today we're going to dive into trademark basics so that as you are building your brands, you can, have this information in mind and realize the complexity about what can and cannot be trademarked, how that process goes, and then how you maintain those trademarks over time. So I'll just share my screen and we will get started. Okay. Just confirm you guys can see that. I would just drop a yes in the chat if you can see my screen. Perfect. Okay. Actually, let me go back here to the beginning. So I am Melissa Gray. I have been licensed since 2011 in both Florida and Texas. I have a background in IP, but I also served in-house for a large manufacturing and distribution company. And I think that's important because it gives me some context as a in-house legal professional and how to interact with business owners and executive teams and things beyond just what my private practice training afforded me at the beginning. So my primary focus for the last, for the majority of my career has actually been in IP space, primarily trademarks. And last year, I opened my law firm to help small business owners have access to legal representation and try and take the intimidation out of contacting a legal professional, and hope to be a resource to not only Dallas but people across the country with respect to trademarks on how we can help them. So I have a trademark background. I've been attorney of record on thousands of trademarks throughout my career and prosecuted them across the globe. But to get started, let's just touch on the types of intellectual property, because I think this is where people get tripped up on like the nomenclature. So there are 4 buckets of IP to just be aware of in your business. You've got trademarks, which we're going to touch on today, copyrights, patents, and trade secrets. So your trademarks are source identifiers. So those are things where you hear a noise, you see a logo, you see a brand name, and okay, that product or service originates from that company. So that's what we'll be talking about today, and we'll dive in on what can and cannot be trademarked. The next bucket that's the most common is copyrights, and copyrights protect artistic works. So think of your photographs, your paintings, the text of your books that you draft, poetry, movies. Those are all subject to copyright protection. Then there's patents. Patents are your inventions. There's several types of patents: utility and design, and those are things that you can file to as you create these ideas and put them down and want to prevent other people from infringing on those ideas. And then trade secrets, the last bucket here, is actually not something that you can file for. This is one, and I like to think of it as more of like a black box. So I like to always use the example of the recipe for Coca-Cola. It's not something that they can patent. It's not something that they can trademark. The recipe itself is actually just a secret, but it's a secret that they need to keep confidential. And if it got out, it would be detrimental to them as a business. So those are the 2 things that you need to qualify as a trade secret. So let's dive into trademarks specifically. So you might see these symbols out in the world, and I think they're really important to just highlight because they actually have specific meanings. So you might see a TM or an SM. A TM indicates that that person considers that logo, that slogan, that mark a trademark, meaning that they want to have that be an identifier of source for them. A SM is similar to a TM, but it's for services. And you often see the circle R here at the bottom, and that is actually indicating that it's a registered trademark. That means that they have gone through the steps with the federal government, whether it's in the United States or somewhere else, to register that mark officially with the government. And that has meaning, and it has penalties if you use that circle R improperly. So if you have something that you're considering a trademark and you're in the application process or you haven't yet filed, you can use this TM at any time, but you can't use the circle R until you have a federal registration. And even then, you can only use the R if you're using your mark in connection with what you filed and registered it for. So that is an important note. And lastly, it's the C, and that is for copyrights only. You can use that regardless of whether you've registered or not. You see it very commonly on the bottom of web pages and things, but you can also put it, you put it on the front cover of your books. It's just a notice to third parties that this is a copyrighted work. So let's dive into trademark basics, why they matter. So the reason you want to be clear about what your trademark is because trademarks actually serve to protect consumers. They build trust with the public. They indicate to them that they can expect a certain quality, a certain service level when they see something originate from that source. So if you, for this slide, I use Starbucks as an example. They are all over the world, but you know when you go into Starbucks that you're going to get the consistency of service, the consistency of the products that they sell, of the coffee that they brew. And it's very, that would be something that they need to protect, and also gives you assurance as a consumer when you go into their stores that that is the level of product and service that you are going to get when you go there. Now, it can also be detrimental to you, right? Like if you have a situation where that brand gets tarnished in some way by the steps that a company has taken and their dealings, that has a negative impact on that mark. But that mark itself has value because we indicate that value as consumers. So we hear that, and then you know where it came from, and you have an immediate, almost visceral reaction to seeing it, and you have certain expectations of it when you see it. So these are all examples of some of the most prominent and valuable trademarks in the world. Okay, so actually the market value of Apple, for example, like a third of their valuation is for their IP portfolio, and those companies that are valued the highest in America and abroad have the largest IP portfolios. So it is something that as you scale, as you grow, these are assets that increase the value of your company. So the technical definition of a trademark is a word, symbol, or words legally registered or established by use representing a company or a product. And when you're considering the types of trademarks, there are two that you can file for with the USPTO. One is a standard character mark, and the other is a design mark. So we'll talk about those, but a standard character mark protects words without regard to the color, font, or style. So if you file a standard character mark with the USPTO, which is the United States Patent and Trademark Office, then you are able to protect that word any shape or form. You're not tied to a certain color. You're not tied to a certain font. You're not tied to a lockup in any way. So as you continue to have iterations of logos over time, that carries with you no matter how you choose to portray that mark in your marketing materials. So if you only have the ability to file one type, the standard character mark is almost always what I recommend, because it is the biggest bang for your buck, and it doesn't tie you down in terms of design features as you grow your business. And a design mark is the opposite. You're including claims to the fanciful things in your design, whether it's a portion of a logo or the script. You are saying that is part of what I want to claim in this trademark. So I just want to dispel a couple of trademark myths off the bat as we dive into, how you would choose a strong trademark, because these are things I hear from small business owners a lot. And one of the main goals I have is to just instill this idea that as you build your business, if you decide this is the path that you want to go down, it's so important to give yourself permission to act more, larger than you are. You might be small today, but you've got to have the end in mind as you set up the foundation of your business, because you can just make things so much harder if you don't. So here's the most common myths I just want to go through. I have a business entity, so that would be an LLC or a corporation, so I don't need to file a trademark. I hear that a lot. That is inaccurate. Your business entity is just a company that is a legal entity that's protecting your personal assets. That could be anything. That it could Melissa H. Gray PLLC. That's a business entity, right? But I don't have to perform services under that. That is just an entity that I use for contracts and the like. If you think about a big corporation, they're going to have levels of entities that no one ever sees. The trademark is what's consumer facing, what is out there in the public. So just because you have a business entity, that is not enough, nor does it give you automatic rights in that mark. So those are two distinct things. The second myth I want to highlight here is my business is too small for a federal trademark. Again, beginning with the end in mind is something important, but it's also you're small today, but you are investing time, money, you're getting domain names, social media handles. Do you really want to set yourself up for being in a position to have those things not protected after you're spending all that investment of capital up front? So like for me, for example, before I even formed my business entity, I searched the law spot. I put an application in with the USPTO. Like I wanted to make sure that every investment I made, from a domain to social media handles, they were all protected. And I had cleared those things before I put them into practice, no matter how, if I had any clients or not at the very beginning. I didn't want that to be a factor as I started to scale. The third myth is I did a search on the USPTO website and didn't find anything, so I'm good. So you want to be super careful with doing a DIY search, and I could do a whole, side note on how to maybe do it more effectively as a layperson rather than a lawyer. But the USPTO website does not give you things that a trademark attorney is going to get in their search. You are doing an exact match. Okay, but that is not enough to determine whether there's a conflicting mark on the USPTO that's already registered, because they are not going to find things that have variations in spelling. They're not going to find things that are maybe 2 words instead of 1, or that have a character in them that the USPTO is interpreting as a letter. So there are things that an exact match is not going to find, that could be very problematic as you search. So that is good. And I always encourage, start with Google. That is just fine. If you see somebody that has the same name in your space and they're everywhere, that's probably a bad thing. So doing a USPTO search is also a good thing, but it's not going to pull everything that might give you trouble. So just know that. The other one here, they're not in the exact same space, so I can use my mark for services and not get in trouble. That might be true, but the USPTO actually gives a registrant they have a zone of reasonable expansion. So your registration allows you protection in that class as well as the zone of reasonable expansion. So what does that mean? Because that sounds like legal jargon, right? The zone of reasonable expansion is when, for example, you are Bath and Body Works. You file for hand lotions. They sell hand lotions, absolutely. But they also sell candles. So if you're a small business owner and you have a candle brand, but somebody has already filed in connection with body lotions, they're not going to let you have the same name, because this person that has body lotions already has that zone of reasonable expansion to keep people out of the candle space. Just if you're tracking me. So it's not enough that they're not in the exact space. You could still be refused, and that person could still object based on a likelihood of confusion with what you're doing. And then the last one here, I have a registration, so I own my mark in connection with everything worldwide. So once you go through this process and you get a registration, awesome, good job. But that is limited to the country in which you file. So getting a registration in the US does not automatically prevent you from, stopping people in Canada or in Mexico or anywhere else in the world. Those are all actually separate registers, and every country has their own process for registration. There are some treaties that allow a kind of bulk country registration, for the EU, for example, but those are specific to certain geographic areas. So you would just want to talk to somebody about, if you're importing products from there or you're selling there and you need a trademark in those jurisdictions, then that is a separate thing. Okay, so I just wanted to highlight the ability to coexist in the world, right? With the exact same trademark. So you've got Delta Faucets, you've got Delta Airlines, and you've got Delta Dental. No one is going to be confused because they're going to have the context, and all of these companies are functioning in different spaces and different channels of trade. So this is a good just example of how you can use your mark if you stay in your lane, but once you creep over into that zone of reasonable expansion for another brand, it can cause problems. So I just want to highlight that use is important, right? Like a federal registration is sort of your highest protection level in the United States. But by nature of using a mark, you do have what they call common law rights. So those are based on use only. And if you have to rely on them, you are limited to use with your exact good or service in the exact geographic area where you are using it. So this limits you in the case of enforcement. And that is why having only that to rely on is just going to be limited. We live in an economy, a digital era, right? You are online, you are interacting with people that are in different states. You're providing services or products, most likely nationwide in most cases. If you have an e-commerce site or, even if you have a brick and mortar, people are mobile today, very mobile, and you are probably servicing customers or being provided goods from people outside your particular geographic area, in which case a federal registration has the most advantage. So these are just a few of the advantages of a federal registration. You get a legal presumption that you own the mark. and you have rights to it. So in federal court, that certificate proves ownership, and it eliminates the need for a lot of evidence. And that can save money for people that are solely relying on common law rights. You would have to provide proof of all of that. If you have a federal registration, that eliminates it. You present the piece of paper, and then the burden of proof is actually on the other person to say, no, I was using it first, or no, you did something wrong. But that piece of paper actually, just cuts out a lot of noise at the beginning if you have the need to enforce your mark with a third party. And you can use your registration as a basis for filing protection in foreign countries, which is also an advantage. You have the right to bring a lawsuit in federal court, which, depending on what the circumstances, has the potential for attorney's fees, treble damages, which is like 3x the damages. It depends on the circumstances, and those might not be available to everyone, but you get statutory remedies that you wouldn't otherwise get with just relying on a common law use, with meaning that you have not filed with the United States government. Another advantage is that R symbol that we talked about earlier, and you are putting third parties on notice that you have a registration. So if someone sees that, it is a deterrent. And the last one, which I don't think gets brought up enough, but you can actually register your trademark with United States Customs and Border Protection, and they can help stop importation of goods with infringing marks. So if you're in like the luxury goods space, or maybe not even luxury, but if you have a good that is coming across borders and like through a customs office, then they can actually help you eliminate gray goods from counterfeit goods from entering the market. So what can you file a trademark for? Let's get to like the fun stuff, because one of my favorite things about my job is actually seeing these things in the world. You go to the store and you see all these brands actually working and serving as identifiers. So the shape of this Coke bottle is a trademark, as is the name, Coca-Cola, the symbol, the M, the slogan, I'm loving it. You can trademark a color, and you can also trademark like a logo type, which is like a combination of elements. So these are just some examples of color trademarks, which I thought were really cool. You've got Tiffany blue, John Deere green, you've got the T-Mobile pink. There's also sounds that you can trademark. I always use the example because my husband has the app on his phone for ESPN. So whenever like he gets a notification, it goes da-na-na. So that is actually a trademark for ESPN. And whenever anyone hears it, oh, that's ESPN. So if you have elements like that you are working with in your business, and you're providing services or goods that have these unique elements that people connect with you, these can be trademarks, and they are things that you would want to keep competitors from being able to use and infringe upon, because they have a value to your customers and your business. And this is I put this slide in here because I think it's a really interesting highlight of what can and cannot be trademarked. So for example, Honey Nut on the left, or Honey Nut Cheerios on the left, and then you see, this is the Walmart brand of Honey Nut O's. So Honey Nut cannot be trademarked. You can't stop anyone from describing the flavor Honey Nut on a product because it's descriptive of the flavor, but they can't use Cheerios. But the look and feel of the actual products are not necessarily protectable. It's the brand on the products most of the time. So you can, the packaging and things, like for instance, the Coke bottle, you can rise to the level of trademark, but it has to be acquired over time. Okay. So let's go through, this is the spectrum of strength of a trademark. So people talk about, that's not a strong mark. Well, what does that mean? So we'll go from the weakest to the strongest. How about? So the absolute no chance you're going to get a trademark is something that's generic, which is a term like the corner store, or if you're trying to trademark the term pens for pens, and that is something that you want to stay away from at all costs. You also want to stay away from descriptive terms if you can, because those are going to be used by other people to describe their goods. So you're never going to have exclusive rights to use that term in connection with your goods if you use that as a source identifier. So I use the example here. If you had a yogurt company call their yogurt creamy, like, you can't prevent any other yogurt company from describing their yogurt as creamy, because yogurt is creamy. It's kind of a gross example, but then you have that you're getting into the better marks on the right here. So you've got descriptive plus a secondary meaning. So copper tone is a really good example. You're using the tanning oil to get a copper tone, so it's suggestive, or it has a secondary meaning, but it's not quite descriptive of a tanning lotion. You've got suggestive, which is Netflix and things like Netflix, and then you've got your arbitrary or fanciful marks. So these are things that are completely made up. Google is a great example of this. You have no reason to use the word Google in connection with anything unless you're Google, because it's made up. So this is just a nice visual of the best, the most protectable versus the least protectable. So, and here's where I get into the typical scenarios. I worked with hundreds of business owners over time, and most of people are in reactive mode, not proactive mode. And that's one of the things that I'm trying to change in helping small business owners. I would love to help more people be proactive, because it's very difficult to fix things after you're already knee deep in what you're doing. And this is the scenario I see. You say, I'm going to start a business and use this name. And then you pay all this money to build your domain, invest, you get your social media handles, and then business is going good, and you start to get some traction and visibility. And then you get the attention of somebody that has, could potentially be mad by you using a similar name. And then you get a cease and desist letter. I have literally had this scenario happen almost 7 years after someone was in business. They got a cease and desist letter and had to rebrand, spend $60,000 on signage, social media, all the marketing things, the attorney's fees. It was ridiculous because they didn't do the step at the beginning to make sure that it was clear on the front end. So this is the way that it should happen. Yes, it looks more complicated, but you identify your concept, you run your search, you know what's out there, then you file your application. If it's clear, then you get your social media and your domain, you get your registration, and you just continue on this process of monitoring and enforcing your mark and maintaining it over time. So that is much more cost effective. So if you're choosing the application process, getting that going early is key these days, because the USPTO is taking 12 to 18 months to basically go from start to finish. And it used to be much shorter, but the path to registration is just long. There has been an influx in applications throughout the United States, and they just don't have the staff to process all of them. So this is a typical path. You file your application, it gets reviewed by an examiner at the USPTO. They will issue an office action to address anything in the application that needs to be corrected. 75% of applications get issued office actions. So that if you're wondering what your chance of sailing through is, it's not good. And that can range, in terms of the type of office action that you get, but most of the time they want to complain about something and you have to fix it. Then it gets published, allowed, or registered, and then you have to continue to maintain it. So there's over 500,000 trademarks filed in the US every year. So this is something that the volume is not something that is easy to process from the government standpoint. So the more you can appease them and use the forms properly and correct filing procedure from the beginning, the better chance of success you have. So again, they have a 75% rejection rate. And I just wanted to highlight this as just a comparison, right? The average, I charge $750 for a clearance search. I'm going to look at the federal trademark office. I'm going to look at state. I'm going to look at common law. I'm going to look at apps on iTunes, all the things. Not iTunes, App Store. But that's $750. If you want to rebrand, that can, $20,000 is an average, but you have to buy your domain. You have to go use the time and effort to get a new designer for all your materials. You have to potentially destroy things that are already in the market or relabel them. That is a very cumbersome process. And then the average cost of a lawsuit, and I put $150K. I think with inflation, it's actually gone up. But a trademark lawsuit is no joke, and you're in federal court, and it's expensive. There's depositions, there's discovery, lots of time and effort, where if you just invest a little bit at the front end, you can save yourself so much pain down the road. So if you are more of a DIYer, I want to just highlight the most common mistakes that people make when filing their mark. They fail to search. They fail to identify their goods and services accurately, and then they fail to demonstrate proper use. So we'll go through each of those things. I already said the process is long. It's 12 to 18 months. And improper filing can actually invalidate your registration. So it opens yourself up to liability for infringement if you fail to properly search. And then as far as strategic advice on the front end, someone guiding you at the beginning is going to be able to navigate issues that you might not see. So the majority of my counseling with a client is not about the application itself. It's about, what are we going to put in the application? You know what you do, but how do we say it and maybe get around some of the search results that we found? Or how do we craft the description in a way that an examiner is not going to issue us a descriptiveness refusal? Like, those are things that you can address on the front end with just some strategic advice that are very hard to correct after a filing has already been done. But if you are going to do the DIY route, I am giving you some resources here. This is the United States Patent and Trademark Office website. And I'm going to send out this recording, so don't feel like you have to write these down. But this is uspto.gov. If you are looking to identify the class of goods or services that you're in, this trademark ID manual is it's just like a search bar. You can put, if you have t-shirts, you can type in t-shirts and it'll tell you, okay, you class 25, and it'll give you some example descriptions. Where that gets complicated is if you are in a technology space, especially, or if the goods that you produce are made of a specific material. That class is actually determined by the material your good is made out of in most cases. So it's not necessarily what the good is, it's how it's made. For example, like if you make the same thing out of metal and plastic, but those are two different classes, because metal goods are in one class and plastic goods are in another. So just, and this is where those intricacies of vetting the classes up front and having advice on that end comes in handy. But always start with Google too, and don't hesitate to like pause if you see somebody in your same space, because chances are if you can Google them, they're going to be able to Google you later. So it's just one of those things where if you know they're out there and exist, don't plow ahead if you could see that you're in the same space. You need to choose something else. And then, of course, my website for if you need help and are issued an office action after the fact. So just a few things to highlight about trademarks in general. You have to use it or you lose it. The rights can go on forever with your trademark as long as you continue to use it in commerce and maintain it. So the proof of use has to be submitted after registration between the 5th and 6th year following your certificate of registration issuance. And then on the 10th year, and then every 10 years after that. So that can go on forever as long as you are able to show proof to the trademark office every time that renewal date comes up. There is a presumption of that you've abandoned your mark if you don't use it for 3 years. So if you want to maintain something, make sure that you're putting out use, even if something is more cyclical in nature, like let's say you only use a specific mark during football season or on Christmas. That's okay. You're allowed to only have use once a year, but that use has to be on some sort of cycle that you can explain and be continuous without gaps. And then you need to monitor that mark and make sure that no third parties are creeping into your space. So there are actually some very economical services to notify you of potential applicants or registrants on the USPTO and even worldwide. So if you are really trying to sort of hand that off and have that be automated, there are services out there that can basically send you an email on anything that comes up that might be infringing on your trademark. And if nothing else, you need to just set up Google alerts for your brand name so that you know, and you can make sure that the Google alerts that are coming in are actually you and not a third party that has, popped up that you need to address. And if that happens, you need to enforce your mark by saying something. There are cease and desist letters, there are social media takedowns, there are UDRPs, which is like the domain name avenue. There are lots of different ways that you can go about addressing third-party uses that are improper. And if you don't, that can dilute your rights over time and eventually result in someone being able to cancel your mark by claiming that you did not enforce it. So if you have a situation like that, that is when you really need to reach out to a professional to, educate yourself on what your options are with respect to enforcement. So I hope that was helpful. I am offering an exclusive offer to those who've attended this webinar. I would love to help those of you today that have an interest in doing a clearance search or have a new brand name that you're vetting. And I'm happy to have a free consultation with you to discuss your mark. But if you elect to move forward, I want to gift you 10% off your clearance search and your federal trademark application professional fees. That can't include the USPTO fees, which are standard. But if you book an appointment with me and you just put webinar in the appointment booking, then I would love to extend this offer to you so that you can get your application on file and maybe start out 2024 knowing that you've got that trademark protection underway. But I hope that was helpful, and visit my website at thelawspot.com if you want to just have some more resources that you can look at as you start your business journey, or you continue your business journey. But thank you to each of you for joining me today, and I'll talk to you soon.